Let's talk with Richard J. Rilling of the law office of Richard J. Rilling in Boca Raton, Florida, who processes these deals. And Richard, are you on the line?
Yes, I am, John.
Good morning.
It's a pleasure to be with you.
Pleasure to have you on. I guess I should just start out by getting right to it. You do the legal work for these. What makes these safe for purchasers relative to other investments out there?
Well, there are a few considerations that go into processing a structured settlement transfer. I like to really talk about the two types of risk involved in these sort of transactions. One being the default risk, and the other being the transactional risk. The default risk is related to, these are annuities which are issued by insurance companies, usually large, very well capitalized insurance companies. And they are rated by the big rating agencies. So the default risk is related to those, the potential or the possibility of those companies going out of business for one reason or another, being undercapitalized or being liquidated for some reason, and eventually not living up to their obligation to make the payments under the annuity policy. Now, that default risk is quite low in these sort of transactions because generally you're dealing with very large, very well-capitalized insurance companies, these State Farms and Allstates and Transamericas of the world. And as life companies, they are required to have certain capital reserves in order to pay out their obligations. So that default risk in these transactions is quite low. The other type of risk, the transactional risk, is really the one I am most involved in and keep my eye on and try to minimize in my involvement in these transactions. And that transactional risk has a number of different elements, but basically it relates to the underwriting of the transaction and the processing and making sure essentially you're doing all of your homework, the due diligence involved in processing the transaction. It starts with confirming who you're dealing with as far as the annuitant, the structured settlement recipient, making sure that you're verifying their identity, making sure that you're identifying any other interested parties who may be entitled to notice. Most states have now enacted what we call an SSPA, or Structured Settlement Protection Act, whereby in whatever state where the customer is a resident, we would need to file a petition in court and serve various interested parties with a notice of hearing advising all of those interested parties that there's a proposed transaction. And one of the important parts is identifying who are those interested parties, who's entitled to notice under the statute. In most cases, it's the annuitant themselves, the person selling their payments, as well as most of the statutes are very similar, but they do vary in some small respects. So in certain cases, you need to serve beneficiaries or irrevocable beneficiaries, whoever that annuitant has designated to receive the payments upon their death. Sometimes you have to serve them. You also have to make sure you're serving the insurance companies, the issuer of the policy, as well as the owner of the policy. Usually with structured settlements, the policy itself, the annuity policy itself, is actually owned by an insurance company. It's not actually owned by the annuitant, although they have the right to receive the payments. So in processing the transactions, you want to make sure that you're complying with the SSPA, or the local statute which governs a structured settlement transfer. And there are other issues as well, such as determining whether or not someone is currently in a bankruptcy. If they are, then the payments which they're selling may be subject to the trustee, the bankruptcy trustee's jurisdiction. So you need to keep an eye out for that, and that's one of the things my office would normally do, is run bankruptcy checks and run lien and judgment checks to see if the party who's selling the payments to my client, normally the factoring company, to see if that party selling the payments has any liens or judgments against them, which we might need to be concerned about, and which could create a cloud on, in legal terms, what we call a cloud on the title to these payments which are being sold in this transaction.
Would we not have the right to pay those liens off from the sale proceeds as a way
Yeah,
of clearing those?
Absolutely, John. In most cases, the contract which the customer enters into, or the annuitant enters into with the factoring company, usually says that the factoring company, in the event that they discover any liens or judgments which may affect the title of these payments, the factoring company would have the right to pay off those liens or judgments. It happens on some occasions, a small percentage of occasions where that needs to be done. Oftentimes, if it's a small enough lien or judgment, you can pay it off entirely, or sometimes in the context of paying it off, negotiate it down, which oftentimes does work out well for the customer, because they end up, in addition to receiving their money from the transaction, having one more debt paid off, and sometimes at a much lower amount than it would have otherwise been.
That doesn't really affect the buyer, the price and the rate of return, if part of the seller's proceeds are used to pay off the lien.
No, it doesn't.
Yes.
It doesn't. Usually, that money comes directly out of the money which the annuitant will receive, or the seller will receive from the transaction. So it does not affect, on the ultimate purchaser's side, it doesn't really affect the transaction at all, other than the fact that the ultimate purchaser has the knowledge that this lien that was out there has been taken care of, it's been paid off, and it's no longer an issue.
That's good for both sides. Sounds good.
Oh, absolutely. Absolutely.
Well, I'm very pleased to have somebody like you working on our deals. I mean, this is an industrial-grade process, and I think that's what has made this grow, because the transactional risk is managed as well as the investment risk.
Absolutely. One of the things which has really caused this industry to grow was the enactment of all of these Structured Settlement Protection Acts throughout the various states in the U.S., and the vast majority of states now have these. Those acts outline a procedure in order to process these transactions, a legal procedure which ultimately results in a court order, whereby the court approves the transaction and orders that the annuity issuer make the payments to the assignee, whether it be the factoring company or their subsequent purchaser. But that's one of the things that's really caused a tremendous growth in this industry, is the security and the certainty involved in actually having a court order approving the transaction, and having a known process whereby it increases the safety and security of these sorts of transactions by making sure that you've complied with those statutes, and once you have a good measure of safety and security that ultimately, if you purchase these payments, you will receive them.
Seems like that was a good thing. IRS Section 5891, together with, is it 48 states that have structured settlement transfer statutes?
I believe it may be 48 states, 47, 48 states now. I don't have the number on the top of my head, but I have quite a thick book on my desk here, which contains all the state statutes. And
yes.
Yeah, 26 U.S.C.A. Section 5891 was actually enacted back in, I believe it was 2001, 2002, and that's actually it's funny enough, it's an Internal Revenue Code penalty provision, which says that if someone purchases structured settlement payments without complying with these state statutes, that there's a penalty involved. But if you comply with the state statutes, there would not be a penalty involved to the purchaser. So that along with
no
the various state statutes,
no tax to the seller,
and no tax to the seller as well.
Exciting.
Yeah, absolutely. In these cases where the initial settlement was a result of a personal injury claim,
yes,
the structured settlement payments, the payments that are paid out over time, are not generally taxable to the annuitant. And what 5891 says is that in the event of a subsequent structured settlement transaction whereby the annuitant sells their payments and receives a lump sum, that lump sum will maintain its character as a non-taxable asset to the annuitant.
That is excellent. Well, this has been very enlightening, and Richard, I really appreciate this. And
thank you very much, John.
We may
Appreciate the opportunity.
We may have some follow-up questions at some point from our listeners, but thank you so much for coming on today.
My pleasure. Thank you for having me.
You're very welcome. Thank you.